P. Canadian Foundation for Children, Youth and the Law v. Canada, 1s. Cr. 76, 2004 SCC4, known also as the spanking case, is a leading charter decision of the Supreme Court of Canada where the court upheld Section 43 of the Criminal Code that allowed for a defense for assaulting children as not in violation of Section 7, Section 12 or Section 15 of the Charter. Background: the Canadian Foundation for Children, Youth and the Law applied for a declaration to strike down Section 43 of the Criminal Code, which states, under the section entitled Protection of Persons in Authority, 43, every schoolteacher, parent, a person standing in the place of a parent is justified in using force by way of correction toward a pupil or child, as the case may be, who is under his care, if the force does not exceed what is reasonable under the circumstances, the basis of which is because the provision violates Section 7 of the Canadian Charter because it fails to give procedural protections to children, does not further the best interests of the child, and is both overbroad and vague. Section 12 of the Charter because it constitutes cruel and unusual punishment or treatment. Section 15 of the Charter because it denies children the legal protection against assaults that is accorded to adults. Ruling: the Supreme Court handed down its 6-3 decision on January 30, 2004. The majority opinion was written by Chief Justice McLaughlin with Gondia Iacobici, Major Bastaraki and Lebel J.J. concurring. Section 7 protects individuals from violation of the personal security. McLaughlin found that there was no violation of the section. The Crown had conceded that the law adversely affected the child's security of person, so the issue was whether the violation offended a principle of fundamental justice. The Foundation proposes 3 claims as mentioned above. McLaughlin rejected the first claim that it failed to give procedural protection as children receive all the same protection as anyone else. On the second claim, she rejects that the best interests of the child is a principle of fundamental justice, as there is no consensus that it is vital or fundamental to our societal notion of justice. On the third claim, she rejects the claim that the law is vague and overbroad on grounds that the law delineates a risk zone for criminal sanction. She examines the meaning of reasonable under the circumstances, stating that it includes only minor corrective force of a transitory and trifling nature, but it does not include corporal punishment of children under 2 or teenagers, or degrading, inhuman or harmful conduct, such as discipline by the use of objects, blows or slabs to the head, or acts of anger. The test is purely objective, McLaughlin claims. Section 12 prevents cruel and unusual punishment, citing the standard of showing cruel and unusual punishment from R.V. Smith 1s. Cr. 1045 as so excessive as to outrage standards of decency. McLaughlin rejects the claim as the section only permits corrective force that is reasonable, thus cannot be excessive by definition. Section 15 is the equality guarantee that protects individuals from discrimination. McLaughlin examines the claim using the analytical framework from Law v. Canada. When identifying from whose perspective the analysis must be, McLaughlin notes that rather than take the perspective of a young child, which would prove too difficult, it must be viewed from the perspective of a reasonable person acting on behalf of a child and apprised of the law. McLaughlin says that the claim hinges on demonstrating the lack of correspondence between the distinction and the claimant's characteristics or circumstances. On this point, she acknowledges that children need to be protected, and in furtherance of this goal, parents and teachers require protection as well. Section 43 decriminalizes only minimal force of transient or trivial impact, and to remove such protection would be dangerous dangerous as it would criminalize acts such as placing an unwilling child in a chair for a 5-minute timeout, which would risk destroying the family.